Thank you. Good morning, ladies and gentlemen, and welcome to this meeting of the Angus Licensing Board. Do we have any apologies for absence?
There's no apologies, convener. As I said, the convener's having difficulty this morning connecting, but he's asked you to take the chair in the meantime.
Thank you. Do we have any declarations of interest? No. Right, in which case, can we move to item 3, the minutes of the previous meeting, the meeting of the minutes of this meeting of the board 2022. Are members content that they are a true record? I'm seeing nods, so thank you. And if we go to item 4, the new premises license under the Licensing Act 2005 for A Ray's Restaurant, 79 High Street, Montrose. Do we have an officer to lead this?
Convener, Vice Convener, sorry, the applicant is in the meeting.
Right.
Hi there.
Yeah, and that would be, sorry, I don't have that on my notes.
No.
Mr. Margaroli, Councillor Mayor.
Yes.
Right.
Unfortunately, I'm unable to get my webcam working.
Don't worry, we can hear you.
Great.
Would you like to tell us about your application?
Sure. So my name is Mark Caroli. I'm originally Dutch and married to my Scottish wife. And we've opened a restaurant on the Montrose High called Ray's. And we're basically like a small a la carte bistro who sits 40 people inside, and if weather permits, 20 people outside.
Are there any questions from members to the applicant? No, that's going to be useful. Right, so if we can go through the description of the premises: a restaurant seating 40, which is located on the High Street in Montrose, with a terrace seating 20. I note that our building standards have recommended that it should be 40 total, inside and out.
Yes.
Are members satisfied with that? And the core times on sales Sunday to Thursday 11 till 2400, Friday and Saturday 11 till 0100, off sales Monday to Sunday 11 till 2200, these hours being within board policy. Are members satisfied with that? And the activities 3, within and out with core hours: receptions including weddings, funerals, birthdays, retirements, etc., club or other group meetings and recorded music, within core hours only, restaurant facilities, bar meals, live performances and outdoor drinking. Members satisfied with that? Yeah. And then 4, any other activities may be provided, but no alcohol will be sold or supplied out with core licensing hours. Are we satisfied? Yeah. And then the children and young persons, I believe these are the standard model conditions. Are we happy with that? And then capacity, inside 40, outside when weather permits, but 40 total, inside and out maximum. Are you satisfied with that? Yep.
Yeah.
In which case, I'm moving that this application is approved in the terms given. Are members satisfied to approve it?
Agreed.
Yep.
Agreed.
Thank you very much.
Vice Convener, could I draw your attention to the outside conditions that the LSO has proposed?
Thank you, Fiona.
Yep, sorry, yes, there are with the outside of
Is it
having got a noise management plan, subject to the standard outdoor drinking area conditions prohibiting the use after 9 p.m. and no music being played outside or inside with the intention to be heard outside. Are members satisfied? Right.
I think Mrs. hand up, Vice Convener.
Sorry,
yes.
I haven't got a hand up here.
Apologies. Yes, Vice Convener, I wonder if I could just clarify, please, that the applicant is content with the proposal with respect to the 40 indoors and outdoors, i.e. is agreeable to changing the operating plan to reflect that.
Of
Mr.
course.
Margaroli, are you satisfied?
Yes, I am.
Thank you.
Right. Okay. Can we then move on to agenda item 5?
Sorry, Councillor Moore, would you just let Mr. Margaroli know that his application has been granted and he can leave the meeting?
Yep, there you are, Mr. Margaroli.
Thank you.
Thank you so much. Have a
You're
great
welcome.
day. Bye-bye.
Bye. Right. Agenda item 5A, we have Arbroath Football Club, Gayfield Park, Dundee Road, Arbroath. And I believe we have Mr. Paul Reid representing the club in attendance. Am I correct? Is Mr. Reid there?
I believe he is. Yes, he's in the meeting, Vice Convener.
Right. Would you like to present your case, Mr. Reid? I'm not seeing or hearing from him.
I think, Mr. Reid, you're on mute still. If you take off the mute button.
Is there?
Mr. Reid, can you hear us okay?
He seems to be having problems. No.
Mr. Reid, if you try and take off your mute button.
No, he's still on mute. Right.
Convener, there doesn't seem to be any this one. Let's proceed.
Right. Okay. Pull the papers up. Right. It's a request to vary. Do members have any questions on this application? No. In which case, we're asking to add off sales Sunday to Monday, 10 to 2200, which are within board policy. Seasonal Boxing Day. Operating plan, add restaurant facilities, receptions, including weddings, funerals, birthdays, retirements, etc., club or other group meetings, recorded music, live performances, dance facilities, gaming, indoor/outdoor sports and televised sport out with core hours, films within and out with core hours, amend activities out with core hours statement to the club seeks to maximise the use of the facilities. Breakfast service may take place from 0800 onwards, and funerals, meetings, conferences and the like may take place out with core hours. Background music will be played both within and out with core hours. Major sporting events are often televised out with core hours, and these may be shown subject to member demand. Although activities may take licensing hours, no alcohol will be sold or supplied unless under the authority of an extended hours certificate. amending their other activities statement to catering may be provided for various events such as sportsmen, hospitality events and the like, and we may hold quiz nights, race nights, casino night, raising events, birthday parties and the like, but no alcohol will be sold or supplied unless under the authority of an extended hours certificate. The capacity for us is 30 square metres. We have had the new merchandise shop and redevelopment reception area layout plans supplied. The premises licensed to include there will be a shop at the entrance of the premises which will sell football merchandise, and a range of alcohol will be available for off sales. Now, I know that we have comments from both building standards and licensing standards. Building standards to comment and advisors of the position.
Yes, thank you, Vice Convener. The application obviously includes the provision of a new shop and office building. That is subject to a building warrant and completion certificate in our legislation. There was a building warrant applied for on the 6th of October, but still to date this has not been approved. I would note that building warrant and completion certificate should be in place prior to occupying that building.
Thank you.
Good morning. The only issue I have is that Mr. Reid has said he'd like gaming out with core hours. I think we need to stipulate what gaming it is and whether it's, the board agrees to that.
Right, thank you. And have we been able to get hold of Mr. Breed yet? I don't even see him in the meeting now. I think he's dropped off. I think that is something that we delegate to the licensing standards officer to determine, or do we have to determine that on the matter of the gaming? Looking for some advice here.
I think
it's Jennifer that has to answer that.
Mrs. Burns is be able to advise you, Vice Convener.
Mrs. Burns.
Yes. Is it the case that the applicant is still endeavouring to enter the meeting? The presumption is that they are anticipating that they will be able to comment, and certainly would be entitled to hear any comments, including some that have already been made. And so I wonder whether it would be appropriate if the applicant is still endeavouring to enter the meeting, if in fact we defer and discuss these once we've managed to clarify that they are entitled to fair notice.
Right. Okay. In which case, I'm moving that we shall defer this until after item 9. That's after item 8. So that we can get chance for the applicant to re-enter the meeting and comment. Are members satisfied with that? I know I've got Councillor Durno and Councillor King wanting to speak, but do you wish to speak now or wait until?
I've got a proposal, Convener. I think we can get past all of this except the gaming. And we could quite easily leave the gaming as a delegated power to be discussed later. If it has to come back to a future board, then it has to come back to a future board. I think this is probably all okay, knowing that one of the directors of the club is a long-serving solicitor with Thorntons, who used to represent many clients before the board. So I'm quite sure this is absolutely in order. I would suggest that we grant it with a temporary suspension on the gaming until it's cleared up. And
we also require the completion certificate before.
That's a separate matter. They cannot proceed legally without that. So that's just a note on the thing that they can't do it until they've got their certificate.
Right. Are members happy to proceed on that basis? And Mrs. Burns,
Mrs. Burns is looking to speak.
Yes.
Yes, Councillor. I believe that it would be appropriate for me to give some legal advice with respect to gaming, and in view of my earlier comments, it would not seem appropriate to grant delegated authority with respect to that while suspending that element of it without the applicant having been given some opportunity to comment.
Right. I note that the applicant has now managed to enter the meeting. Mr. Reid, I don't know how much you have missed. The board are happy with all the alcohol issues. It is merely the gaming. Could you elucidate a little on what you were foreseeing?
Mr. Reid, you're still on mute. Can you manage to take the mute button off?
Mr. Reid, can you hear us?
Yeah. It's maybe the microphone button that you want to put on, if it's maybe closed off.
Thank you very much. I'll be up.
Right. I'm going to move we defer this while an officer contacts Mr. Reid and gets him connected properly. Okay, yeah. Can we therefore move to item 5B? And I note that our convener has entered the meeting, so I will hand over to Councillor Fotheringham. I think Councillor Fotheringham's there. I can see him on the list. No? Are you there, Councillor Fotheringham? I can see him there, but he's on mute. Right.
There we go. We're here now. Oh, technology today, folks. Apologies for me for that. I don't know what went wrong this morning. I just wouldn't even open the emails or anything up. Okay, I take it we're now moving on to 5B, which is the Grey Harlings Hotel in Montrose.
Yep.
I believe we have Kevin Watson and Chloe Henderson, the applicants, in attendance, and Mr. Kevin Pridwell, the objector, is also, I believe, in attendance. So either Kevin or Chloe, do you want to speak to your application? And there may be questions from board members after it. Thank you.
At all. So good morning, my name's Chloe. If you're not familiar with myself, I am here with Keith Watson also, just for any additional questions. Keith is our director here. So I'll just quickly summarise our application. I know you've already seen the report. Basically, we have made an application to vary our current premise licence after a licence review and following advice from the Licensing Standards Officer, Nikki Corletto. We asked her for some advice on our current position, and as a result, with that advice in mind, we have made this application. So we are looking to diversify the services that we offer here at the hotel as a result of a couple of things. One being inquiries that we've received from members of the public with regards to holding functions here. And also as an additional way to generate income into the business. Obviously, it's been difficult recently for a number of industries over the last couple of years, and we would like to look into other ways of bringing revenue into the business. And as I say, the inquiry that we'd received that sparked the chat that I had with Mrs. Corletto originally was someone requesting if they could hold a small wedding reception in spring next year for up to 40 people. So that is the context for our application. It has been brought to our attention that we would need to obviously vary our licence, and add in some additional activities to allow us to accommodate these functions. So I'll just quickly run through what we've asked for at the moment. So we have asked for a variation to the core times for on sales, so to change our terminal hours Sunday to Thursday from 11 PM to midnight, and on Friday and Saturday from midnight to 1 AM. And we've also asked for the addition of off sales Monday to Sunday from 11 AM opening hour to 10 PM terminal hour, which are all within board policy. We've also, as a result of this, asked to add seasonal variations for Christmas Eve, Christmas Day, Boxing Day, Hogmanay and New Year's Day, obviously to offer us an additional hour of operations should either of those special seasonal days occur on a Sunday to Thursday. With regards to our operating plan, we have asked to add some additional activities both out with and within core hours. Briefly, just to confirm, they are conference facilities, receptions including weddings, funerals, birthdays and retirements, club and other group meetings, indoor, outdoor sports and films. So to provide a bit of context to that, we are looking to add some of those activities out with our core hours for specific instances where club meetings or funeral receptions may start prior to 11 AM in the morning, but also to add them within our core hours to allow us to take on the functions for the inquiries that we've received. We are also looking to add bar meals, live performances and dance facilities within core hours. Those activities are complementary to the initial activities that I've just mentioned there. And indeed, the example of bar meals is just complementary to the restaurant facilities that we're already licensed for. And also recorded music out with core hours. So this has been asked for on the basis of background music to play through the public areas of the hotel prior to 11 AM in the morning at a low level when cleaning's happening, you know, restocking the bar and things like that. I would like to make clear here that some of the activities that we have asked to operate out with core hours, that really refers to out with the opening hour, so prior to 11 AM in the morning and not the terminal hour. So we are not looking to seek permission to offer these facilities or activities into the wee small hours. As I say, it is more for functions where the nature of them would necessitate that they start prior to 11 AM. So if we were to offer conference facilities to businesses for meetings before 11 AM and, as I say, funeral receptions prior to 11 AM. I'll also make a note on indoor outdoor sports as well. That is purely just so that we have the provision to allow our pool table to be used prior to 11 AM also. So that's really an overview of what we've asked for at the moment. We would just note also that we have received an objection and also requests from Environmental Health for further information with regards to noise. We acknowledge the objection received and we have responded privately to that, and also we have gone back to Environmental Health providing an updated noise management plan, which is a comprehensive plan outlining the noise risks that we've identified and the steps that we already take and would take further down the line to mitigate that. So that's been provided to Environmental Health alongside existing plans that we have in place for the management of artificial lighting, barrier management, people management, etc. So I think that demonstrates our commitment to operating, you know, responsibly and considerately with regards to our neighbours, residential and business otherwise. And I would also note the point that has been made in the objection also with regards to there being no specified hours for the activities we would like to facilitate out with our core hours. We completely understand the concern there, and we would welcome the opportunity today to provide clarity around that if the board deemed it necessary to set you know, specific hours for those activities that may start prior to 11 AM if that benefits all parties involved. So I think that's everything I would like to say at the moment. Thank you for your time. Thank you for listening, and I'll just await further questions.
Okay, thank you very much, Chloe. That was very detailed and comprehensive. Members, any questions for Ms Henderson? Councillor Moore.
Thank you, Convener. Yes, Ms Henderson. With two areas. One was the indoor-outdoor sports. It is, I presume that you said it was for your pool table. I presume you were not thinking of branching out to have things in the back garden in the summer.
No.
And I'm just a query, why off sales?
Well, we spoke with Mrs Corletto in our review about what we were licensed for originally, and we both felt, and Keith also included, that it would just complement the service that we were able to offer as well. You know, it is standard policy for our business such as ourselves. If somebody, you know, came in and wanted to buy a bottle of wine and take it away with them, if they were having something to eat, or if they were coming in to visit guests that were here, we would just like to be able to offer that as a service. It's not that we're trying to, you know, offer it as an advertised commercial position sort of thing. And no, definitely nothing else sports wise, inside or outside. It's purely just for our pool table.
Thank you. And the only other question, we're talking about noise and environmental health. We're talking about noise near to sensitive receptors. Would you accept that that condition should be that any noise emanating from the building should be inaudible at the nearest noise sensitive premises?
Yes, we would agree with that, and we do already take steps to mitigate that. We monitor our noise on a daily basis here as well. But obviously, if we were to go forward and be granted any of the activities that we've applied for, we would, of course, take additional steps to make sure that that was the case, particularly between the hours of 11 p.m. and 7 a.m. But yes, that is important to us, and I think that's demonstrated in the plan that we've set out in the steps that we already take.
Thank you.
Thank you, Councillor Moore. Anyone else? Questions? No, I have one actually for Mrs. Corletto. I noticed that there was a complaint, Nikki, in 2016 in respect of noise, and a written warning was issued at the time. And then Mr. Coleman, a further complaint which was partly upheld on the 23rd of July 2020 about breach of conditions and COVID regulations. Mrs. Corletto, I take it there's been nothing further? Any other complaints since that date, two years ago?
No, nothing further, Councillor Fotheringham.
Okay, that's great. Thank you very much. Now we'll have an objection from, I think it's Mr. Kevin. My apologies if I don't pronounce your surname right. Mr. Kevin Prudhoe or Prudhoe. Do you want to speak to your objection, Mr. Prudhoe?
Yeah, thank you.
Good morning. No problem. There may be, if you could speak to your letter of objection, and then there may be questions from members afterwards. Thank you.
Okay, thank you. Our grounds for the objection to the application are that the application is inconsistent with the licensing objective of preventing public nuisance, and also understand from the planning department that if the licence were to be approved, planning matters would need to be rectified before proceeding to operate under the new licence terms. We understand that the area officer is advancing the enforcement case 21-00054 UNDV. I understand Daniel Coleman, Planning Enforcement Officer, has contacted the Licensing Board clerk to advise of the planning enforcement position. Public nuisance. When we first looked to purchase our home next to Grey Harlings in late 2013, Grey Harlings was a house operating as a hostel with lapsed temporary permission for hostel operation. The area was quiet, and the 4 houses on the road were surrounded by the golf course. We looked forward to enjoying these peaceful surroundings for our young family. Since then, Grey Harlings has morphed from a house to a licensed hotel with a large beer garden and increased its capacity to 150 people. In the early years, we had to deal with many instances of public nuisance, including a live outdoor band at a wedding in 2015 for over 150 people in the garden immediately next to our house till midnight. The band was so loud our neighbours couldn't hear their television with their windows shut. The issue was discussed informally with the operator, and they were brought into our home to observe our windows vibrating and hear the noise firsthand at our location. We tried to sort this out informally and amicably in good faith, but with this and further instances of public nuisance, the operators did nothing to do anything to address our concerns or manage noise from the premises. I could go on, but another example of public nuisance you may remember is the sound clip I played to the Licensing Board in October 2017, when drunken adults were heard shouting and playing on the bouncy castles, etc. at a children's party. Thankfully, in recent years, the situation has been better, since planning conditions and licensing conditions have restricted the operations and protected our home's amenity. However, with a 30 to 150 person capacity increase and a large beer garden major variation approved in September 21, and this current broad licence application for weddings, dancing, and hours extension till 1 AM at weekends, etc., my wife and I are very apprehensive that we will once again suffer the disturbance that occurred previously. In addition, we understand that the hotel has been up for sale since the last licence variation was granted. As this is a broad licence application, we are concerned that any buyer will no doubt reinterpret any latitude within the licence to their best commercial advantage. So any non-conditioned assurances given by Framework Property Development of how they will manage noise, etc., provide little comfort. Furthermore, as indicated by 2 cases of planning enforcement and the multiple issues documented in the LSO's report, it does not appear to be unusual for Framework Property Development to overlook rules while developing their business. Activities out with court hours and the noise management plan. Planning condition 1B in the hotel's planning permission states a noise management plan is required. This plan shall include measures to restrict the hours of use of outdoor areas associated with the business. Thereafter, the use hereby approved shall be operated only in accordance with the approved noise management plan. We understand from Jenny Burns that any activity in the operating plan for out with core hours can take place at any time outside core hours unless it is time restricted in the operating plan. Consequently, this could subject us to noise of weddings, guests in outdoor drinking areas, etc. for 24 hours a day, even though no alcohol was being consumed. This is in direct contradiction of the noise management plan condition that should include measures to restrict the hours of use of outdoor areas. If the board is minded to approve this application, could we request that activities out with core hours are given a reasonable permitted start time, e.g. 10 AM, to prevent activities commencing at 1:01 AM on a Friday or a Saturday night by drunken partygoers? We would also request that the noise management plan include the requirement to keep windows shut in the lounge, doors shut, the gate to the patio area from the beer garden shut, and the barrier required by the planning permission condition 1A is reinstated, as the beer garden has been operating since September and still no barrier is in place preventing guests from entering the prohibited area between Grey Harlings and our property. We appreciate that Storm Marwyn caused damage, but that was in November, 4 months ago. A copy of the noise management plan was requested to review from the Licensing Board, Planning and Environmental Health, but as yet we have not received a copy. Acoustic music, live performances and dancing. We have previously been heavily disturbed by a ceilidh coming from the lounge area. With this in mind, we are concerned that the acoustic music and dancing proposed in the application will bring a return to this type of disturbance, as ceilidhs would form part of the routine entertainment provided for weddings with up to 150 guests. To prevent any noise from the lounge, which is the closest indoor area to our property and where we have previously been heavily disturbed, the police were in attendance, by non-amplified ceilidh music, we suggest that as the applicant specified in the planning permission application, the function area is restricted to the restaurant cafe area and the lounge is conditioned against use for these activities. And music and live performances are conditioned such that any noise from them is inaudible with any adjacent residential property, as Councillor Moore just alluded to. This is consistent with the existing planning condition 2, which states that all amplified sound associated with the approved use shall be inaudible within any adjacent residential properties. We are extremely concerned that if this application is approved without this condition, the planning condition that was put in place to protect us from noise disturbance will have been circumvented. In summary, we are extremely concerned about the noise that would come from this development and interfere with the peaceful enjoyment of our property. I would ask that the board members give consideration to this objection and ask that the application is refused or at least conditioned to restrict noise disturbance, particularly in the outside area and the lounge, on the grounds that is inconsistent with the licensing objective preventing public nuisance for the reasons discussed. Thank you.
Okay, thank you very much. Ms Burns, I notice your hand's up.
Yes, thank you. you. I comment that there appears to be new information contained within the objection, which the applicant will not have had the benefit of having prior notice of, and the board may wish to consider that and ask the applicant's view with regard to that.
Okay, thank you, Jenny. Okay, Miss Henderson, heard things today that you weren't aware of, I think.
Yeah. Yeah, that's right. So I completely understand, you know, we're reasonable people. We're not some live events venue. We're not looking to do anything wild. We don't do anything wild at the moment. I appreciate that there are residential properties, multiple residential properties surrounding us. There's also other business premises, and we do everything that we reasonably can. And I think the plans that we have in place, both on paper and in actual terms of day-to-day management of the business, demonstrate that we do take that very seriously. And we can only do as much as is reasonably possible within our means for, you know, properties that choose to reside next to hospitality businesses. And we don't ever want to be a concern to any of our neighbours, as I say, business premises, residential premises, anything like that at all. And I think it's unfair to say that we don't take into consideration anything that they have raised as a concern previously. We have provided multiple reassurances in person and via, you know, formal channels of objections and responses and things like that to alleviate concerns. And I appreciate that in the past, certainly prior to my time here at the business, with regards to the one in 2015, the instance that happened there, we appreciate that that shouldn't have happened and that it did happen, and we've always been transparent about that. With regards to the one in 2020, that was an honest mistake, and we held our hands up and we've rectified that, and we've taken steps to work around that as well. So, you know, we are being as open and as transparent as possible about everything that we are doing, and I think it's unfair to say that we don't currently operate responsibly when we demonstrate that we do. We're doing everything that we can reasonably do to ensure that we can both run a business and be considerate neighbours to everyone round about us. Our outdoor area already is licensed only until 9 p.m. and we don't have anybody, you know, outside using that space after 9 p.m. That's an outdoor condition that we've had for a while. We did come to to a board meeting last September. At that time, that was to update our layout plan and our operating plan and update our capacity numbers, because at that time that was as a result of the occasional licenses that we'd had in place that we were allowed to do during the coronavirus pandemic for us to use our outdoor spaces as additional spaces when we weren't allowed to serve alcohol inside, and we were keen to keep that opportunity and rectify our capacity. We didn't do that in September with the foresight that we were going to come and ask for this now, and I think it's unfair to say that we did do that. I appreciate that you know, it may sound excessive to have a capacity of 150 people and then say that we want to take function bookings. I completely understand that. But that is not what we're looking to do. It's different to say that we have a building capacity of 150 people where those groups could be split up between, you know, a group of 30 in our restaurant, 20 people having a conference meeting in our lounge, and, you know, people out in the beer garden, 20 people out there. That is a completely different situation than us organising a function for 150 people for a wedding reception. That's not something we would do. We don't have the facilities to do that. So I understand the concern there, but in actual reality, that isn't what's going to happen. And a few points that were raised during the objection that were mentioned today, they are addressed in our noise management plan. We already say about what we will do with our windows and what we do with our windows and doors. So I'm not going to say anything further on that because I'm confident in everything that we've submitted in our noise management plan. I would like to note also that the comments regarding the barrier are not accurate. We did have the fence and the gate installed, and that was all sent over in October, just after the board meeting that we were at last time. That was all done within timescales. We were dealing with Damien Brennan in building control, and Charles Colvin, who was the enforcement officer at that time. I have since chased that with Damien. I have spoken to him as recently as this morning as well. He advises me that it hasn't been updated, but it should be. And you know, you can come and have a look at the site if you need to. But yes, the tree that fell down in the storm with its 30-foot root ball that's ripped the fence and the gate up, yes, that's caused a bit of a difficulty. And yes, we are a small team and we are still rectifying that at the moment. So even just as of yesterday, our water main that was affected by that has only been fixed now. So I think a little bit of grace should be given for us to rectify that. It was there and it was there for a period of time. We've proved that, and we are in the process. We are in the process of rectifying that. And as Keith has just mentioned, there are still elements of it there at the moment. I can provide pictures. That's no problem at all if the board deems that necessary to have a look at that. And yeah, we have just, you know, we are in in talks with building control and planning to get that all signed off. It's in our best interest to have everything done and to operate responsibly. And again, I don't think it's fair to say that we don't operate responsibly when we demonstrate at every point, and even indeed being here today, that we are wanting to do everything properly, and that we do take our responsibilities very seriously. I don't think there's too much else for me to say there. I think it's discussions that we've already had previously, and I'm not sure if there's ever anything that we can say that would reassure the objector in this instance. Oh, and just lastly, with regards to the sale, we are open about the business being up for sale. It's been up for sale since just before Christmas. That is an unrelated point with regards to our application at the moment. These things can take time, and at the moment, if I'm honest, my concern is the day-to-day recovery of the business and ways to look at generating more income into the business. So I appreciate that point, and that it may look like that, but in actual terms, that is not the situation that's happening at the moment. So if anybody has any further questions, I'm happy to answer them as best I can at the moment.
Okay, thank you, Chloe. There is questions, I think. Councillor Moore.
Yes, thank you, convener. I have questions of a number of people. From Ms. Henderson, what exactly was the extent of the damage from Storm Arwen? We've heard that it took the fence over, I think it was.
Was that tree that came down?
About 50 feet.
Yeah, we've got one of our largest trees on the site, about a 50-foot tree, came down. It did actually impact on the building, but thankfully nobody was hurt, and there was minimal damage. But that is an ongoing insurance process at the moment to get that resolved. So with the root ball of that tree, that was in the area where the fence and the gate, the barrier that we erected was. So when that root ball came up, it's ripped up the fence and the gate, ripped it clean out of the ground, and the water mains as well also. So just yesterday we were getting the water mains repaired and back to where they should be. We've been, over the last few weeks in the better weather, having the site cleared, all the fallen wood removed, and things like that. So we are now in a position that the site is cleared to move forward and reinstate what's not there.
Repair the side of the building.
But yeah, as Keith mentioned there, it's an ongoing insurance process at the moment, and we are waiting to hear back from them before we can rectify the repairs to the gate and the side of the building and the roof and things like that that's been impacted. So
thank you. And from Mr. Prudhoe, was the hotel a hotel when you moved in next door?
No, it wasn't. As I stated at the beginning, it was. I understand it had lapsed. It was a house with lapsed temporary permission to operate as a hostel.
Okay, thank you. And now I've got two other questions. One for Mr. Easton and one from Mrs. Burns. If I can take Mrs. Burns first, the hotel is up for sale. Would I presume that this application being approved would carry on to whoever bought the hotel, and therefore they could operate differently with different hours that we as long as they're out with the core hours. Is that correct?
Yes, that's on the presumption that the licence would be transferred to the new owner. The licence would be transferred in the same state that it was at the time of that transfer.
Thank you. And could we ask Mr. Eason for his view? We've heard a lot about the noise nuisance and this noise management plan. Could I ask, what is your view of this plan? Will it protect the neighbour from noise?
Currently, we don't see any, in relation to the additional activities, we don't see any significant increase in risk of noise nuisance to the surrounding neighbours, provided the activities are managed properly and in line with the noise management plan. We have a draft plan with us just now, and we're liaising with the applicant to ensure the plan is adequate, subject to any decision that's made this morning.
Thank you.
Okay, thank you both. Councillor Whiteside, question. Thank you.
Thanks, convener. Yeah, it seems to me that it's a really well thought through application, and it's good to see businesses being ambitious and trying to expand their core business. And it's good to see the liaison that's going on with council officers in planning this application. I'm just wondering if Ms Henderson can tell us if there has been any complaints from any other neighbours other than the objector that's here today. That would be interesting. In terms of the objection, I also think it's unfair to consider incidents from 2015 from a previous owner, and I also think we definitely can't make a decision based on what ifs. We can't make a decision based on what any potential new owner might do, because there are conditions in place. But if Ms Henderson could ask about other neighbours, that would answer about other neighbours, that would be really helpful.
Yeah, of course, Councillor Whiteside, that's no problem. To date, we've not had any other objections from business or residential premises. It's been repeated objections from Mr. and Mrs. Prudhoe. So no, nobody else has. And as you say, the 2015 instance, apologies, I can't provide any further insight onto that because that was before I was here. I believe we weren't actually on our current premise licence for that. I believe that we were licensed in 2017 as well. So we have rectified that since then. But no, certainly no other objections, just support to date.
Okay, thank you. Councillor Durno, question?
Yeah, thanks, convener. Beth has actually asked a bit of what the question I was going to ask. Obviously familiar with the area. The children's nursery is there, and you've got the golf club as well. So you've obviously, playing golf. They do play golf at night, etc. You've not had anybody complain about people coming in from the golf club or the children's nursery, and it's quite busy, isn't it?
Yes, it is. It is, and the greenkeeper huts and things like that are along there as well. We've got positive relationships with the nursery, other residential neighbours. We work closely with the golf club and the golf links and Ruesleaf as well. So no, there's not been any issues from that, no.
Thank you.
Thank you, Councillor Durno, and thank you, Chloe. Mr. Eason?
Thank you, convener. Mr. Prudhoe did mention the potential for noise from non-amplified music. There is a standard condition which relates to amplified music, and the board may wish to consider amending that condition to include non-amplified music and vocals in this case.
Okay, thank you very much, Mr. Eason. I was going to ask, because obviously noise is a concern for next door and for the objector. Police Scotland are in attendance. Now, they will have been notified of this request to vary, but they have no objections to it or no concerns, I don't think. Can I ask, if Police Scotland if you are here, I think I can't see my list, it's further down, I think. Have you ever been called to these premises because of noise?
Good morning, it's Constable Mass here. On looking at the board papers, I do what's called an incident check of premises that are coming up for applications. So in relation to the address at Trail Drive, our incident log shows an incident on the 17th of July 2020 whereby Mr Prudhoe has phoned in at 22:30 hours in the evening complaining of noise. From the incident log, it looks like police have not been in attendance. They have phoned the hotel and the hotel had said the bar is now closed, so no one attended that incident. And then there was one further incident on the 18th of September 2021, and that was where Mrs Prudhoe is phoned in, and that's been a complaint against the hotel owner, which was found resolved by both parties being spoken to. But there's only been 2 calls that we're aware of. I only go back 2 years when I do my checks before places are coming up to the board.
Okay, thank you very much for that. Any other questions from members? No. Comments? Councillor Moore?
Yes, thank you, Convener. This is really a balancing act between the desires of the business and the concerns of the neighbours. I mean, Storm Arwen did a lot of damage. I know I got 9 trees down in my garden and I'm still sorting out from it. So I can appreciate that it takes time, even though it will be 4 months tomorrow since Storm Arwen hit us. Plus the fact we had Barra, Corrie and all the friends right the way through to Franklin. But I think here that there are concerns. I would move that we amend the noise management plan to say that all noise should be inaudible at the neighbouring property after 9 PM at night. And I think that will address a number of the issues. If there is then noise, we can act on it, the police can act on it. We cannot do anything about planning because that is outside our remit. If planning decide to act on something or have an enforcement case, that is not within our remit. So, you know, we just have to say, well, planning will get on with their side. But certainly with that amendment, I will move that it's approved.
Thank you very much, Councillor Moore. Chloe, we're actually on comments from members. If it's something really you want to come back on, I will allow it, but this is not normal.
Yeah, of course, sorry. It was just to clarify the noise management plan we've submitted did say that noise would be inaudible between 11 PM and 7 AM already. That was based on board policy that I'd had a look at. So if there was a motion to bring that earlier to 9 PM, then that would be suitable for us. So it was just to confirm that, that's all.
Okay, thank you very much, Chloe. Anyone else? Right, I think I'm going to agree with Councillor Moore. I think that condition should be put on, and hopefully that will satisfy the neighbours. And obviously, if there is noise, the neighbours have got absolutely every right to come back to us or phone the police, and they will report that to us anyway, and that can be dealt with at a later date. I think I'm going to move that we grant, with the condition that Councillor Moore has said about all the music, and also subject to Mr. Reeson's department, because I think the noise management plan is still to be finalised. So I'm going to move that we grant it subject to ECP being happy with it. Is that agreed?
Agreed.
Agreed.
Okay, thank you all for your attendance this morning.
Convener.
Yes, Mrs. Anderson, sorry.
Before we move on, we think we've now got Mr. Reid sorted for the previous one, which was the Arbroath Football Club. Would it be possible to take that one next to see if we can get Mr. Reid into the meeting now?
Absolutely. Now, because Councillor Moore started that, will
yes,
you
can spectate, but Councillor Moore will have to finish this one on, and you can't take part in this one.
No, that's fine. Thank you very much.
Okay, so I'm going to ask Mr. Reid to see if he can now take his mute off and can hear us, Mr. Reid. If not, Mrs. Malley will phone him and put him on loudspeaker.
Can I just comment that Mr. Prudhoe and Ms. Henderson can leave the meeting if they wish, because we've dealt with their application.
That's great. Thank you so much. Take care.
Thank you.
Mr. Reid, can you unmute yourself now and hear us? I think Karen's going to bring him in on the telephone. Karen, our business reporter is saying he may have to come completely off the call as there may be interference if he's on both the screen and the telephone.
Fiona, I'm just contacting Mr. Reid at the moment now on my phone. Give me a second.
Thank you, Karen.
The wonders of technology.
Start the live stream.
Good morning, Mr. Reid. We're glad we've finally been able to contact you. Would you like to speak to your application?
Hello, sorry.
Can you hear us?
Yeah, thank you.
Would you like to speak to your application? The only area that members have a concern about is the gaming.
Okay. Yeah, so in which area was that? Did you say gaming?
Yeah, Mrs. Coletta, would you like to express your concern so that Mr. Reid can address it?
Yes, of course, Councillor Mayor. Mr. Reid, I note from your operating plan that you've changed it to include gaming out with core hours as well as within core hours. Could you clarify what gaming that will be? Because there's some gaming that isn't allowed out with core hours.
So what we would be looking at there would be if we were to hold any sort of fundraising dinners. So it would be raffles, race nights, auctions, that sort of thing.
Okay, so there's not going to be gaming machines?
No gaming machines or on-site betting or anything like that. It would just be purely for private or club functions where we were to incorporate a raffle or a race night or something on that form.
That's totally fine. I'm happy with that then, Councillor Moore. Thank you.
Thank you. Right, given our licensing standards officer is content, are we agreeable to approve the application?
Agreed.
Agreed. Agreed.
Agreed.
Mr. Greed, your application is approved. Good luck.
Thank you very much. I appreciate your time. Thanks very much, everyone.
Thank you. And I shall pass back to Councillor Fotheringham again.
Thank you very much, Councillor Moore. Okay, members, the next agenda item is agenda item number 6, premises licences under Licensing Scotland Act 2005, review of premises licences. And I have to say to you that the Brown Horse in Brechin has now paid. And also I'm going to ask members, because the workhouse in Forfar is now a hairdresser's and has been for some considerable time, that we agree to revoke the licence for that premises.
Agreed.
Is that agreed?
Convener.
Yes, Councillor King.
Can we have the licensing standards officer interview the proprietor of the Brown Horse to find out just exactly why it has taken them so long to pay for their licence, and that they have only paid it once it was going to be under review?
Yeah, I agree, Councillor King. I think we've got to hammer home a message that we're not going to put up with this consistent late payment. Mrs. Carletto, yeah.
Councillor King, the licence holder, Mr. Renlinson, has unfortunately been severely ill. He's been going through chemo at 9 Wells, and this has totally fell off his radar. He didn't receive any of the letters that was sent out because it went to South Esk Developments and they hadn't forwarded the letters on to him. So as soon as he realised, when he got the notification of the board, that's when he contacted us.
In that case, if the letters were not going to the licensee direct, can we construct a root and branch check on all licensees in Angus to make sure that we have the correct address to send any communications to, and not to owners rather than the occupants?
I think moving forward, any annual fee has to be addressed to the licence holder, which is what the business support team did. Unfortunately, the licence holder didn't contact Mr. Renlinson to tell him about the payment. It is the licence holder's responsibility. But obviously they have an agreement between themselves that Mr. Renlinson pays the fee.
In that case, can we send a final warning to the licence holder in this case to say that any matters of this nature must either be dealt with immediately by them or be immediately forwarded to the person that's going to pay it?
Yeah, I'll note that down to speak to the business support team. Thank you.
Right, thank you.
Okay, thank you both. Councillor Moore.
Yes. 2 things, Convener. One is that I did ask that we asked for explanations last time, and I was told that once they had paid, we didn't have the right to. So I don't know whether we could. The other thing is that with regard to the Brown Horse and the non-payment, this is the 2nd consecutive year that they've been on this list. And I think that the licence holder should be informed that it is their responsibility and it is them that we should be proceeding against, not the individual who is.
Is that not what happens anyway, Councillor Moore? I'm not sure. Mrs. Carletto will keep us right on that, I think.
Yes, it is the licensee's responsibility, but in this case, the licensee hasn't communicated with the person operating the premises, and that's where the downfall has come. And we aren't obliged to write to the person running the business. We have to write to the licence holder.
And it is the licence holder's responsibility to make sure it's paid.
Yes, that's correct.
Okay, Councillor Moore, thank you.
Yep.
Councillor Durno.
I just wondered, why can't we do direct debit every year like they do with everything else, like your TV licence and your green bin and whatever? Why can't we just bring it up to modern day? And okay, maybe if they give up their business and they pay the licence, they might get the money back, you know, but to chase people time, it's getting a wee bit outdated. Can we not just set up a direct debit with all our licences and then we can guarantee the money's in the bank?
Okay, Mrs. Corletto, is that a possibility for the? Obviously, it'll be a new board if it's a change. If I don't know if that's a policy or it's just something that we do in Angus.
I'm not sure. You would have to speak to Jennifer Burns on that, because I'm not sure on the policies for Angus how payments can be made. I know we give them a variety of ways, by cheque, by card, by backs, but I don't know if they can set up direct debits for annual fees.
Okay, well, we'll just ask the question. Maybe Ms Burns can tell us now, or if she knows. If not, she can get back to you, Councillor Dunno, because it's quite a good idea, I think. Ms Burns?
Yes, I don't know in terms of the operations of the council whether that's feasible. I can certainly make inquiries as to that. Obviously, this is the licensing board that we're referring to as opposed to the council itself, but I can certainly make inquiries about that. And for example, with respect to any changes, because it is assumed that the fee will change from year to year. But I can certainly make inquiries and we can get back to the board with respect to that.
Well, we manage okay, you know, paying all the rest of council things, so I think that would be a good idea. Thank you.
Okay, thank you very much. Both Councillor Moore and Mrs Corletto, are they old hands? I think they are.
Mine's a new one, convener.
Okay, okay.
I'm just thinking that the idea from Councillor Durno is a very sensible one, and I just wonder whether it should be referred to the Angus Local Licence Forum for consideration and get the trades' views.
I'm sure Mrs Anderson can put that on the agenda for the next meeting of the forum. Yeah, she's nodding her head, Councillor Moore, so that's fine. Good. Anyone else? Okay, well, we've dealt with the thing anyway, so is that report agreed?
Agreed.
Okay, thank you very much, members. The next one is agenda item number 7, and it's an appeal to the Sheriff Court, a report by the clerk to the board. You'll have all read this. The recommendations basically are to note 1 and 2. Are there any comments on this? No. Is that report then noted?
Noted. Okay,
thank you very much.
Sorry, convener, I think Councillor Durno, does Councillor Durno want to say something?
Oh yes, Councillor Durno, sorry, I see your hand now.
I just wanted to say that I thought it was sad that it came to going to the court, because we can't have a policy that everybody gets open till 2 o'clock in the morning, and I think if this is the way that people are going to go to the court if they don't get open till 2 in the morning, it's going to be horrendous for all the rest of the licenses. So just a point made there that it was done fair and square on the day, and I just think it's sad that we had to go to the court to go through this. Thank you.
Yes, thank you, Councillor Dunno. It may be something, you know, that a new board, when it's looking at its policy, and I think if the legal team will keep me right here, we have to look at that, do we? Within 18 months of an election, a new board being formed. So it may be something that we're going to have to look at, because you're absolutely right, Brenda. If this is going to be what they're going to do every time the board makes a democratic decision, then we may have to re-look at it. But that's just an opinion. Okay, is that report noted then?
Agreed.
Okay, thank you very much. Just change the screen. And number 8 is the premises licenses request to vary under the Licensing Scotland Act 2005. And it's the one coming back again, bar 1320 in the Westport and Arbroath. Now, I have to say, members, that Mr. Glass, the agent, is unwell with COVID. He's unable to attend the board today, and he's asked for a deferral of this item. Do we agree then to defer? Because I think it's only fair. This has gone to court, and he'll want to come back, and then whatever, if it's this board, if it's a special meeting or the new board, but I'm going to move that we defer it. But before I do, Councillor Whiteside.
Thanks, convener. I was just going to ask, although it's not quite so relevant if we're deferring the matter, but I was just because you missed the start of the meeting when we were declaring an interest, given the fact that you were in the press this morning about this item, would it have been appropriate to declare an interest for yourself? It was a point of clarification, really.
I did get a phone call, and that's why I mentioned it. Maybe something that a new board has to look at. That was my comment to the press, and I hope that's what they've printed. I didn't make any sort of comment and judgment on this board, but it may be something that a new board has to look at within the new policy. But thank you, Councillor Whiteside. Yes, Mrs. Anderson, I will make a declaration of interest on that. That the press did contact me regarding this, not particular item, but the fact that we may have to look at a revision to the policy in the new policy. So thank you, Beth. I wasn't aware it was in today. Okay, then, do we agree then to defer this report for Mr.
Convener?
Oh yes, sorry, Councillor King.
Yes, I agree with you that this should be deferred, but it should be deferred to the new board because we're running out of time. Trying to cram in further meetings between now and May is going to be very difficult, especially as the Chief Executive has indicated that meetings were supposed to stop on March the 11th. We've now had half a dozen meetings scheduled after March the 11th, and I'm finding it very, very difficult to keep up with what's going on because I'm trying to organise things like holidays in this period, and I'm finding that people are trying to organise me into meetings. I think anything further that comes up should be deferred until the new board is in place, and possibly even until after you determine new policy. Because I've been quite clear on where we're going with this. I made my feelings clear a number of meetings ago when I said you've opened the door and now you've wedged it open so you can drive a coach and horses through it. That's exactly where we are. If we hadn't have cracked on our policy a couple of years ago, then we wouldn't be in this position now. But it's always the same. You give something that seems like a good idea to one set of premises and everybody else notices it and says, oh, they've got an extra hour, we'll go for an extra hour. And that's why you have this one.
Okay, thank you, Councillor King. Yeah, I agree. We should leave this, defer this to a meeting of the new board, and possibly, as Councillor King said, once even the policy is looked at. But I think it should certainly be the new board because we've only got 5 weeks to go. Ms. Burns, sorry.
Thank you, convener. Just wonder whether it is essential to consider that point, i.e. which particular board will consider it. There are some legal questions under consideration at the moment with respect to that particular question. There are potential implications, and I wonder therefore whether it is possible to leave that particular point, i.e. which particular board would consider this, given that there could be some implications which I'm not able to define and elaborate on at this particular moment.
Okay, so what you're advising then, Ms. Burns, is just make a straight deferral and that's it?
Yes, although obviously if it was the board's preference that it be deferred to the new board, then that's duly noted, shall I say. But if advice was to the effect that it should be a special board, then that would be accommodated.
Okay. Councillor King, we'll still go for the new board? Alec, you're on mute.
Yeah, I put myself back on mute. Yes, I'll accept the fact that Mrs. Burns is saying there are recommendations that should go to the new board, but if there are legal circumstances that make it necessary for us to have a special board meeting, then we'll just have to do so. But it's very unsatisfactory once we're entering into the close period before an election to expect members to find time at short notice when their diaries have been cleared by the administration.
Okay, bearing what Councillor King has said and Ms. Burns' advice, I'm going to move to defer. Is that agreed?
Agreed.
Okay, thank you very much, members. The next item is agenda item number 9, and it's occasional licences We're asked to note under delegated approvals. Is that noted?
Noted.
Agreed.
Number 10, premises licenses, minor variations under delegated approvals. Are they noted?
Noted.
Agreed.
Number 11, personal licenses under delegated approvals. Are they noted?
Noted.
Noted.
And number 12 is extended hours under delegated approvals. Are they noted?
Noted.
Agreed.
Thank you. Number 13, members. If I just move my screen, it's a new personal license application and it's a notice of conviction. And it's an application for a personal license from David Cripps, and Police Scotland have submitted a letter.
Convener,
Yes, Mrs. Anderson.
I think there's been a suggestion that these items be maybe taken off the live stream as they're sensitive information, but it'll be for the board to decide.
Okay, if that's the case, then I'm going to move that we pause the live stream. Is that agreed?
Agreed.
Okay, thank you very much.